This is part of the Project 2025 agenda to limit the authority of the courts, to limit the checks on the executive. It's part of their broader assault on the judiciary. The courts shouldn't have to do this just to get Trump to comply with the law. This is like storied precedent of the Supreme Court, and we're having to jump through all of these hoops just to ensure that the basic provisions of our Constitution are being followed. So if this was a little bit trying for you, imagine how the lawyers feel. Imagine how the judge feels. Hey folks, please like, comment, and subscribe, and make sure to check out my newsletter. Information is in the description. If you recall, a few weeks ago, there was this decision on universal injunctions. You guys remember that? Everyone was talking about universal injunctions. This was a case, and I'm showing it to you right now, Trump v. Casa, okay? This is the decision that was rendered by Amy Coney Barrett, in which it limited the authority of Article 3 judges to issue universal injunctions. If you guys recall that decision, it was a opinion interpreting the Judiciary Act of 1789. Look, I'm going to zoom in so you know I'm not talking crap here. And it basically said that via the Judiciary Act of 1789, Congress designed the Article 3 courts to basically incorporate the equitable principles of equity courts of equity of around that time. And courts of equity are somewhat flexible in applying their doctrines, but the kind of relief that courts can issue under the Judiciary Act of 1789 is fundamentally limited to the examples of equitable remedies that existed at the time of its passage, taking a lot of inspiration and influence from British common law and other cases and example remedies of that era. Now, understand fundamentally what this decision was about and what it was not about. The Trump administration actually did not appeal the underlying merits issue, right? The underlying merits issue deals with the birthright citizenship issue. Trump is trying to change the Constitution. It's been understood that the citizenship clause of the 14th Amendment grants citizenship to all persons born in the United States who are, quote, subject to the jurisdiction thereof. That carve out, though the Trump administration would like to make a meal out of it and make it be something bigger than it is only intended to incorporate some of the traditional exclusions on birthright citizenship based on territory. And those apply typically to invading armies, but we're not talking about mere illegal immigrants or mere criminals, right? We're talking about military forces coming into other places and conquering land. People born under those circumstances aren't given citizenship. The children of ambassadors. And there was some case law on the children of American Indians who were likened to, not being subject to the jurisdiction of the United States in some respect. That said, those exclusions are pretty narrow. And in general, there's a case called Wong Kim Ark and other follow-on cases that have established that you are a citizen of the United States if you are born within the territory of the United States. There are some interesting side questions about if you're born in one of the territories of the United States. And there's interesting case on that. At some point, I'm doing a video on, which you all should, that will be available on the Patreon eventually. And interesting questions about what if I'm not born in the territory of the United States, as in the states, in the continental United States or in Hawaii or whatever, but I'm just born in one of the territories of the United States? Does the citizenship clause apply? That's an interesting question. But it's not one that's on offer here because, of course, what matters here, kind of the big question is, can the Trump administration, which is what they try to do, limit birthright citizenship to only some groups of people who are here either illegally or not on a temporary basis? The categories of exclusions that the Trump administration tried to argue were contained within this proviso, subject to the jurisdiction thereof, were a category that has never, ever been recognized as an exception. And in my opinion, the express command of the Supreme Court in Wong Kim Ark and other cases excludes it. But they try to argue that children of mothers who are here either without any status or here on a temporary basis and whose fathers are not either green card holders or citizens themselves are excluded. So it's kind of two categories there. The children of mothers who are here illegally and whose fathers are not green card holders or citizens, and the children of mothers who are here temporarily and whose fathers are not green card holders or U.S. citizens. Two categories there. And when this came up, it kind of had like a 30-day pause before it was implemented to allow for some very questionable decisions that would need to be made regarding how to implement this. So like, are you going to go to every single hospital and do like a kind of immigration test for all of these hospitals to see if they get their benefits? All of the administrative issues that this would cause were raising a lot of eyebrows. But this, by the way, was not a surprise. If you go back to my Twitter, I was predicting that the administration would do this. And that's not like I was insightful in predicting it. They were talking about doing this kind of stuff. So none of this required genius to know that they were going to do it in advance. Very illegal, in my opinion. And no fewer than, I think, 4 or 5 courts initially held it to be illegal and issued varying types of relief, including, at issue in this Supreme Court case, a universal injunction. It's sometimes referred to as a nationwide injunction, but the court admonishes us and corrects us in this opinion, in the Casa decision, to think of them as universal injunctions, because the ruling here is not really about territoriality. And it's not, as I mentioned just now, about the merits here. The court was not really looking to the merits of the underlying rationale of the Trump administration, which I have argued and continue to argue is fundamentally flawed, at odds with our history, at odds with the case law. The Trump administration did not appeal its failures at the district court level or the Court of Appeals levels on a substantive basis. It appealed only on the notion that the district courts, the various courts that issued these universal injunctions, that is to say, injunctions that apply to protect other individuals besides the parties in the case, that was both unconstitutional and unlawful under the statute. Unconstitutional and unlawful under the statute. I take something that's unconstitutional to also be unlawful, but there was a statutory argument and there was a constitutional argument. And it's important for you guys to think about this. One thing that I think will clarify is separating in your mind an opinion, and an order, right? An opinion that only applies to one person might, in the course of coming to that determination that only applies to one person, right? Let's say there's a contract dispute between two parties. And in coming to a decision on whether to grant summary judgment for one party or another, that is, to grant relief to one party or another, the court makes a pronouncement on how a particular language in a clause is going to be interpreted. Now, by the terms of whatever opinion that is sort of produced by that decision, it will only apply to the parties in the case. And this is like a classic two-party dispute, a contract dispute. So by the terms of the opinion, right, in the order, there's only a judicial order that applies to two parties in that example. But the statement of law is still precedent. One way to think about this is maybe in a case that we've been talking about a little bit in the Bold Guy versus Ethan Klein fair use decision, right? The fair use determination in that case, there was only really, an order to grant judgment in favor of Ethan Klein in that case. Didn't apply more broadly, the order, but it was still the opinion still had precedent. It was still a precedent opinion, right? Even though it was a district court, and it's still persuasive authority. So other people, for example, in recent cases out of the Ninth Circuit or recently initiated lawsuits in the Ninth Circuit, might look to the precedent of the Bold Guy video case, notwithstanding the fact that there's not an order at issue there. They'll look to that case and say, oh, this looks like, maybe it will be persuasive, maybe it's a good idea, and it will have some effect. It will have the effect that it has. In the case of the Supreme Court precedent, the thought is that those kinds of precedents, to the extent that they apply to issues of federal law typically, or constitutional law, right, which is federal law, that will have binding precedental effect. Not necessarily an order, though, right? Even in the case of Supreme Court precedent, which is binding on all other courts to the extent that it's interpreting and applying federal law, notwithstanding that it's binding precedent, doesn't mean that it's an order. An order is like a command. You must do this, or it's a kind of thing, right? That a judge, a kind of relief that the judge is ordering. That is, that's a little circular there, right? But the judge is commanding either a party or the government, right? Government can be a party, to do something. Separate in your head the notion of an order to do something and precedent. So all of these cases that interpret the citizenship clause of the 14th Amendment, no one is saying they couldn't render that decision as to the particular parties at issue in that case. What Trump was claiming was you can't bind the people who are non-parties, who aren't on the other side of the V. It will be precedent, right? It will be circuit precedent, or it'll be a district court, precedent. And even in the case of a Supreme Court decision, that will be precedent, but it won't necessarily be an order. Once you separate those two categories in your head, it starts to make more sense what the Supreme Court was decided in this case and what it wasn't decided in the case. What it was deciding, simply speaking, was, does the Judiciary Act of 1789 allow courts to grant these kinds of orders, these kinds of injunctions, that kind of relief, which is sweeping? And the Supreme Court said no. But it said no in a kind of weird way, especially for people who aren't used to this sort of thing. So it defined universal injunctions pretty much as injunctions that protect non-parties and that apply to them, broader than the parties. But it left kind of exceptions, carve-outs. One exception of that is if the kind of injunction is needed for a kind of indivisible relief, to give complete relief to one party, you must do a broad kind of injunction. Then, of course, you can issue a broad kind of injunction. The best example of that is kind of like a nuisance case. There's a bunch of pollution. There's a big, pollutant over there. If you order an injunction, part of ordering the injunction saying you have to stop all sort of pollutants, by its nature, even though you're only ordering one party, it's going to benefit. It's going to have ancillary benefits to other parties. So that's a kind of exception. And the other exception was the use of class actions, which is a kind of invention designed to bring in people who are not typically thought of as, wouldn't usually be parties, as kind of parties, as a class. There are different kinds of classes. There's a complicated certification process that we'll talk more about. I don't agree with the court's opinion in Casa, but that's not really what we're talking about today. I've already talked about why I don't agree with the opinion. The opinion grounded its analysis in a kind of historical examination of the kind of writs that existed, the kind of remedies that existed around the time of the passage of the Judiciary Act of 1789. They didn't, however, rule on constitutional grounds, right? This wasn't a constitutional decision. The court punted on that. They didn't need to address it because they could address it just by doing a statutory argument. That's a canon of statutory construction, or I don't know if it's a rule of construction. It's constitutional avoidance. Maybe it's not, in this case, a statutory term of construction. It's more a principle of the court. They're not going to decide things that they don't need to resolve to issue relief and have an opinion. It's not needed. So the court didn't address the Article 3 power, which is a broader assertion by the Trump administration, which is, even if Congress had authorized universal injunctions under the Judiciary Act of 1789, that itself would be unconstitutional, right? That the act vesting in the judiciary, right, Article 3 courts, the courts that are made pursuant to Article 3 of the U.S. federal Constitution, that were Congress to attempt to give them this power, the law attempting to give them this power itself would be unconstitutional. It's a broader claim, but the court didn't need to address it because you had the Judiciary Act. And that argument, the court weighed in the favor of the Trump administration. So the Trump administration is not appealing those substantive matters about the birthright citizenship issue, only appealing the power of the courts to issue complete relief, issue relief to non-parties. I'm sort of glancing over a lot of disagreement I have with the opinion, and you should always second guess the framing of the Supreme Court and of all these courts. Like, why should we even think about such things as injunctions or orders, right? An injunction is basically telling someone to do something or not do something, right? Order to do something or to prohibit them from doing something. It's an order from a court, you might think of. Why would we think of those orders as necessarily protecting of someone, right? Or having a scope with a denominator in terms of for whom it applies. And that's a big problem that Justice Jackson has with that framing. So you should question that framing initially, but we're now in the role, because it's the precedent of the court, to apply it. But before I move on to the actual follow-on decision from this, I want to ask if you have questions about the setup here from the Supreme Court's ruling. So the Supreme Court did not say that birthright citizenship is interpretable the way Trump says it is. They merely said that the courts don't have the powers to issue the kind of broad relief under the rationale that they had given. I'll let you guys ask some questions and talk about some practicalities for now about why this is a little dangerous. It's a little dangerous because in a normal administration, you would think that the courts would give, to the extent they're issuing binding precedent, that Trump would not just ignore it as to other parties, right? One, that they would even follow an order, right? Like, that's a separate issue. The Trump administration has violated several orders. The Trump administration has taken many orders on many of these cases and wiped their ass with it. So there's some question about whether they would follow an order at all. In my opinion, they violated the Supreme Court's order with respect to Kilmar Abrego Garcia, but they're also ignoring precedent, right? They're ignoring the precedent of Wong Kim Ark, which is this case that I referenced, and its progeny. They're ignoring the precedent in other cases and trying to overturn it, using trivial arguments sometimes, and sometimes the court is giving them far too much credit. When I say the court here, I mean the Supreme Court. I think that the intermediate appellate courts and the district courts are doing a pretty decent job here. So under normal circumstances, under a normal administration that is good faith or better faith than what the current administration is, you would think not as big of a deal. Not as big of a deal because, if it's not a universal injunction, we expect that the president is going to follow the law. And at a very sort of minimum level, they're going to apply the law of the various circuits. Wherever the law is as such, right? Like, they're going to follow the precedent. Notwithstanding the fact that it's not a direct order, we expect that the executive is faithful about their oath and their willingness to follow their oath, to uphold the law. A little bit of a bigger deal here where the Trump administration has shown that it's only really willing to be good faith even then, right? Like, even when there's a direct order, they go kicking and screaming if they go at all, but they really push and push and push and push and push. Famously, the Trump administration would not commit to following circuit precedent. They said, obviously, we'll follow the precedent of the Supreme Court of the United States, but they did not commit to following circuit precedent, which is alarming and was noted by the members of the court here. I want to show you a footnote in Amy Coney Barrett's opinion here, which references the government's contention there. But another reason why this is alarming is the fact that this is all kind of a Project 2025 agenda item. The idea of weakening the courts. Here you have a footnote that says our decision rests solely on the statutory authority that federal courts possess under the Judiciary Act. We express no view on the Article 3 argument. So this is just to show you that I was correct about the scope of the opinion here. It's a statutory argument, not an Article 3 constitutional argument. But this is part of the Project 2025 agenda to limit the authority of the courts, to limit the checks on the executive. Very much something that the Russell Vaughts of the world have ideologically been aiming to do. And it's part of their broader assault on the judiciary. It's also alarming because there are bad faith litigation tactics that the Trump administration could employ to attempt to ever let a case get to the Supreme Court at all. So one of the tactics that has been proposed and people are fearing is that the administration said we'll follow Supreme Court precedent. But what if they just tactically choose not to appeal any of the decisions that go against them to the Supreme Court? And then really the rights would be only for people who were able to afford lawyers to walk into court and waive some precedent in the face of a judge, and it wouldn't apply broader than that. even assuming that the Supreme Court were listened to. By the way, for all you law nerds here, the court cites non-mutual offensive issue preclusion, or also known as non-mutual offensive collateral estoppel. These are terms and issues that we're not going to dive into today, but note that for anyone who has taken a complex litigation class, there are ways that you can extend rulings to non-parties via certain doctrines of issue preclusion, certain kinds of injunctions until now, and then, of course, the class action device, which we'll talk about momentarily. The dissent worries that the Citizenship Clause challenge will never reach this court because if the plaintiffs continue to prevail, they will have no reason to petition for certiorari. That is, if everyone keeps winning, right? If all of the plaintiffs who are saying, hey, you're doing illegal stuff with the Citizenship Clause thing, if all of them keep winning, why would they ever appeal to the Supreme Court? And if the government keeps losing, it will have no incentive to file a petition here because the outcome of such an appeal would be preordained. But at oral argument, the Solicitor General acknowledged that challenges to the executive order are pending in multiple circuits. And when asked directly, when you lose one of those, do you intend to seek certiorari? And the Solicitor General responded, yes, absolutely. So they're relying on the representation from the Solicitor General, aka the government, the administration, that they will actually seek certiorari to the Supreme Court if they lose in one of the circuit courts. And while the dissent speculates that the government would disregard an unfavorable opinion from this court, that is the Supreme Court, the Solicitor General represented that the government will respect both the judgments and the opinions of this court. So the Supreme Court is trusting, I would say naively, I would say foolishly perhaps, that the executive branch is going to play it on the up and up and is going to actually be good faith and intend to seek relief in the Supreme Court and actually follow Supreme Court precedent, which I would doubt highly. Anyway, once again, that is the setup here. The setup here is the following. The Supreme Court said you can't use universal injunctions. It's a limitation from the Judiciary Act of 1789. Historically, you only get the equitable remedies that courts of quote-unquote equity had, and they didn't have this kind of remedy. The closest analog would be a class action style device. You have that at your disposal, or if you really need to use an injunction in which, in order to give complete relief, it requires binding non-parties to some extent, or giving protections to non-parties from the injunction. I don't agree with this ruling. I think it's a bad ruling. I think it's a dangerous ruling, but that is the precedent of the court, and we're going to be stuck with it. Basically, as soon as this opinion came down, all of the advocacy organizations, bless them, basically had lawsuits ready to go to use a class action device, to use the class action system under Rule 23 of the Federal Rules of Civil Procedure. So if you see references to Rule 23, that's because Rule 23 is the rule in the Federal Rules of Civil Procedure that describes what you need to do to get a class action, how to certify a class, and how, basically all the procedure for class actions. Also note separately, the Supreme Court said that they are not deciding on whether the other exception, right, to this rule on universal injunctions, it's less of an exception and more of a separate category of thing. That's how the court is conceiving of it. So you might think of it in layman's terms as an exception to the rule, but more accurately, it would be kind of its own separate category of thing, right? A universal injunction is one thing, offering complete relief is another, and a class action is a third thing. But if it helps you to think about these two things as exceptions, you can think of them as exceptions as well, perhaps. Just know that analytically, it's not entirely correct, right? The court isn't going through the process of saying, hey, this is a type of thing that is a universal injunction, and it's not, it's an exception to our rule against them. The court is saying there are no legal universal injunctions under the Judiciary Act of 1789. And separate from these, they're not universal injunctions and they are allowed, are class actions and are courts offering complete relief via an injunction. The states are arguing that in order to have complete relief, there were state plaintiffs in this original Casa case, that in order for them to have complete relief, they need to have it apply more broadly. And that's because of a bunch of administrative costs that they're incurring that won't be alleviated unless and until everyone is forced to follow the rule. That if you have a kind of scattershot approach, and if you don't have complete, like all of the states basically having to follow the same rule, the states are going to have to burden a bunch of administrative costs of like, wait a second, even though you were born in the United States, in our state, you would be considered a United States citizen, but in another state, you wouldn't be considered a U.S. citizen. And we're going to have to figure that out. And we're going to have to, like, if you weren't granted a social security card in a state which doesn't consider you a U.S. citizen, even though we do, we still have a legal requirement to give you these kinds of, like, you understand how it's a headache. And if you have different rules in different places, it can very much cause chaos. And so the states are arguing that actually, in order to get complete relief for our harms, we actually do need a broader set of, an injunction that has more teeth and that is more wide than just like a direct injunction on the parties that only protects the parties. So that litigation is ongoing, where the states are arguing about, in order for us to get complete relief, we need to have a broad injunction. Separately, we have all these other organizations that are filing either amended complaints or new lawsuits asserting the same arguments, but now asking for class certification. The drawback to using class cert is it requires a lot more procedural steps, or I should say, it requires a class certification process. It also binds those non-parties if they have a losing case often. And so it has that advantage potentially for the government. So that's the setup we have. And lo and behold, we have two orders. We have an order granting a preliminary injunction for class-wide purposes. And we have an order granting certification of the provisional class. And what I'm going to do is I'm going to run you through an opinion given by a court that addresses these issues. In summation, nothing has changed on the merits between when the Supreme Court issued their ruling in Casa and now. And nothing has changed then because nothing has changed in the last 100 plus years from when Wong Kim Ark was decided in the 1800s regarding the interpretation of the 14th Amendment. So of course, those of you who are disappointed with like the shortness of the merits interpretation in this particular opinion, I understand, because all these arguments are old as dirt and have already been rejected. But nothing has changed on the merits. The only thing the Supreme Court was successful in doing in Casa was, in my opinion, ahistorically, forcing the courts to go through this useless procedural analysis, giving many more excuses for the Trump administration to violate the law, a lot more procedural arguments that they can levy, and that the district courts are going to have to spend a lot more time, and that litigants are going to have to spend a lot more money just to make sure that rights are being vindicated in this country. And this is a perfect example of it. The court shouldn't have to do this just to get Trump to comply with the law. This is like storied precedent of the Supreme Court. And we're having to jump through all of these hoops just to ensure that the basic provisions of our Constitution are being followed. And the court is having to engage in this useless analysis with bad faith arguments about, there's no commonality, there's no typicality, when everyone knows there's a pure legal question here, a pure legal question about the status of people born physically within the country. So if this was a little bit trying for you, imagine how the lawyers feel. Imagine how the judge feels. Imagine how the petitioners feel in this case. That we have a Supreme Court who's more interested in bad history, in bad textualism, in bad originalism, in bad interpretation, of trying to give Trump every benefit of the doubt always, of having to put footnotes in their fucking opinion saying, oh yeah, Trump said he's going to follow the law. Maybe not the circuit courts, but definitely us. Imagine how it feels to have to actually navigate that system. And you saw the result. The result is having to engage in the Rule 23 analysis for no reason and having to head off bad faith bullshit from the executive branch. But there's no humongous bombshell here from a legal perspective because we know the answer already. That said, if I had to bet, I told you before about 20, 30 minutes ago, that the Supreme Court would uphold their storied precedent. They would uphold Wong Kim Ark, but it's not 100%. And I would say it's not even 90%. I'd say it's like 71%, if I had to put a number on it. You can't trust this court at all. You can't trust this court not to upset its storied precedent. Notwithstanding the fact restrictive immigration laws didn't exist at the time of the drafting or the enactment / ratification of the 14th Amendment, notwithstanding the fact that we have on-point case law, you can't trust this court. It's better that we have it than we don't, but John Roberts is a disgrace. He's a disgrace to the court. He's a disgrace to the country. That we're in this situation can be traceable in some respects to John Roberts, both in Trump versus United States and in the Anderson decision. And for the Anderson decision, that extends to the rest of the Supreme Court as well. So yeah, it's a little bit of a procedural blah, this opinion that I just read to you, but I wanted to put you guys in the mood of the proceduralism, the kinds of arguments that the court might have to contend with in future cases. All of the different arguments that the court will now be tasked with fielding from the Trump administration. Oh, there's no commonality because of this. Oh, let's get discovery for the lawyers of our adequacy of representation. Oh, let's get discovery on the litigants for this. Oh, but you didn't check this box, right? That's what this is about. This is about giving Trump all of the benefit of the doubt, about expanding constantly the powers of the executive branch at the expense of the other branches, and really the other two branches, at the expense of Congress, who passed a law implementing the citizenship clause of the 14th Amendment, and really at the expense of the people, because the people ratified the Constitution and the constitutional amendment at issue here. There's a reason the Constitution says, "We the people hereby ordain and establish," right? Or whatever it says. It is an action. The authors of the Constitution are the people of the United States. But when we let the executive branch under Trump have the benefit of the doubt, this is the kind of shit they pull. A bunch of garbage, trying to make it not apply to future children, trying to limit what courts can do. And really just, again, I want to stress one more time. The Supreme Court is letting Trump make these kinds of arguments, and Trump is showing he doesn't care about following the law. Because he's saying basically, well, even if we have an opinion that says we're not allowed to do this as to currently born people, you can't ever issue an order for future persons because they're not alive yet. Notwithstanding the fact that it would be illegal because you haven't specifically ordered us, because you can't, because they're not born yet, we're not breaking the law.